This is Pod Populi.
Podcast for the people.
Welcome to Business SOS. This is episode 63 of Business SOS podcast. We're continuing the conversation with L.A. Perkins. She was our guest last week, and she stayed a little bit longer to talk more about her book, Why Brand Protection Matters, How to Avoid Costly Mistakes and Increase the Value of Your Business. For those who are watching on YouTube channel, here's the book. Please get it. It's a great read if you're a business owner and want to know how to protect your brand. This is a must read for you. Welcome back to the show, L.A.
Thank you for having me, Rich. Great to be here.
For those who are listening to us for the first time, tell me a little bit more about your background and also your practice.
Well, I've been working as an attorney for almost 28 years now, most of which has been focused on intellectual property. What I do is I help business owners, executives, and entrepreneurs identify and protect their brand assets and enforce their rights when necessary so they can avoid costly mistakes and increase the value of their businesses.
I think it's very important, especially when a business owner spends so much time and effort building the infrastructure of the business, getting the customer base, and building that brand. They want to have that name recognition through social media, through their advertisements, and they kind of skip a step of making sure that brand is protected. And that's where you come in.
Absolutely. So important to protect your brand as early as possible to make sure it's yours and no one else can use it.
So today, I'm very excited about your book, and I'm glad, you gave me a copy and I read it. And, it was a great refresher for me, as I told you before, and really intellectual property and trademark. And our books are very common that we talk about common mistakes. And I particularly like chapter 2, specifically, you talk about various common mistakes that business owners make in reference to protecting their brand or leaving their brand unprotected. So I want to talk about those today.
Great.
So it's gonna be kind of a quiz, so to speak.
Wonderful.
So the first one that I see here is common mistake number 1, registering your company name by setting up a corporate entity without also getting exclusive use of the company name. Tell me more about that one.
Well, Rich, people call me and often say, my name is protected. And I'll say, well, how have you protected it? They say, I've registered it with the Secretary of State. It was available. It's mine. And then I have to share the bad news that does not rise to the level of exclusive trademark rights.
And what can they do about it?
Well, at that point, what they can do is look to see whether that brand name that they're operating under, that they're selling their goods and services, is available to be able to obtain a federal trademark registration.
And I think the last time we talked a little bit more about that in terms of the specifics of how to do that.
Right.
Yeah. So the common mistake number 2, obtaining a domain name without also getting exclusive rights to use that name.
That's another one, which is similar to the first mistake when somebody says, I have the domain name, I've got the name, no one else can use it. Well, a domain name is a great thing to have for your business and necessary in today's times, but it does not establish trademark use, trademark rights, or anything related to that.
Just to give you a little about my background that you might not know, before I became an attorney, I own a job board, a healthcare job board. It actually was one of the first ones in the country, called healthcarerecruitment.com. We're talking back like in 98. So back then, getting a domain name was gold. It was like especially .com domain names. So I was able to get anything healthcare recruitment related. I got all the domain names that I could get my hands to. And I was able to get trademarks for those domains, trademark registration for those domains. Long story short, I was able to sell the company much later in 2004, and the value that they looked at was the domains, but also the trademark registrations that followed those domain names.
Very smart of you. It's critical. If somebody's got a big vision, they want to sell their company down the road, having registered trademarks that you enforce and keep current will increase the value of your business.
Yes, and but back then the domain name now it's important. However, there's so many avenues to promote your business besides having a website that domain names in itself is not, it's not as critical as it used to be, simply because now you have social media that is not dependent on your domain name. You have your videos, you have YouTube channels, you have all the different channels of distribution of your message. That although domain names are important, it's just not as essential as we had them before, say 10, 15 years ago.
Yeah, they're certainly important, like you said, but once a business comes up with a brand name, it's important for them to protect that name on as many social media platforms as they plan to be on and lock down that name.
And talking about domain names and the same topic, we didn't talk about that before, and I know we're going now into a rabbit hole here, is that if you have a cease and desist letter and say you got a trademark infringement lawsuit going against you for a potential mark that they're alleging you're infringing, you could also lose your domain name along with your mark.
100%. In fact, I recently had a situation where I was able to have them turn over their domain name because it infringed my client's trademark rights.
So if you have traffic in that domain name, you say you spend a number of years building that brand with that domain name and it's taken away from you, you're also losing that traffic that goes along with it.
100%. And that's why it's so important to do things correctly up front and to know that you have rights in that name so you don't get into those costly mistakes.
Yes. And also the UDPR action that they can have as well. There's another ways the domain names can be taken away from you.
That's correct. The UDRP is a way that I can't recall what the acronym stands for now.
Uniform Domain Protection, something like that.
That is a way. It's kind of an international action because sometimes it's hard. I've had situations where you're trying to find out who a domain owner is, and you can't because that information is blocked, it's confidential, and so that's one way is to file a UDRP action when you've got an issue and you want to get rights to a domain name.
Basically, for the best benefit of our listeners, is when we buy our domain names, there's a lot of terms and conditions that we all agree to, but we don't read. So we scroll down, we say check.
Isn't that usually the case with everything?
Yes. So
I mean, I think I'm to blame sometimes too for that.
It's too long. We don't read them. We say, yes, we need the domain name. Here it is. Yes. One of those conditions that we all agree to if we're domain name owners is we agree to go through this arbitration process. And that's basically the process that Elena and I are referring to, that there's another way that you can actually lose your domain name through this arbitration process.
That's correct.
So that's what's important to have an IP attorney to help you with these as well. Common mistake number 3, thinking first use of an unregistered trademark in a particular jurisdiction prevents a competitor from obtaining a national trademark rights.
Exactly. Well, what happens in that scenario, somebody is using a brand name, but they didn't make it a priority to protect it and speak to a lawyer. And another company comes along and files a trademark application for the same name, selling the same types of goods or services. Now, when the USPTO, when the application is assigned to a trademark examiner, they're searching the records of the United States Patent and Trademark Office database. They're not going and doing a Google search to see if somebody else is using the name. So it can happen that a company that even started using it after you, that beat you to the punch basically by filing a trademark application before you did, gets the federal trademark registration. It doesn't mean you don't have rights at that point, but it certainly becomes more difficult and costly.
You mentioned trademark searches, and we both get these calls that, I registered a trademark, I searched this, so what do you do? I searched the USPTO database. Can you briefly tell us a little bit more about the type of searches that are involved in searching a trademark, any type of conflict, and why is it important to have an attorney do it for you?
Well, there's different types of searches, and so it's really important to note that, because a lawyer may say they do a knockout search, for example, which is a search of the United States Patent and Trademark Office database. But when I talk about doing a search, I'm talking about a comprehensive trademark search, which is very, very extensive. We use a third-party database to obtain a report for the information. Not only is it searching the the United States Patent and Trademark Office for exact hits and similar hits, it's searching all the records of the Secretary of State in the United States for other businesses that have the business name, state trademark registration. It searches social media, common law as well. So it's very, very, very extensive. And the reason it's good to have a lawyer interpret the results is because you may look at it and think, oh, I can't get that trademark, but that may not be the case. It may be there's so many reasons why it may not be the case that a lawyer will be able to decipher what's going on, to be able to guide you as to the likelihood of you getting the mark, the likelihood of you having a problem.
Yes. When I used to do trademarks, I used to hire a third-party company and just buy the report. It was just the easiest way to do it.
I'm sorry?
When I used to do the trademarks registrations, I had my clients, pay for a third-party company to provide the report, the comprehensive report, and then we can look into whether or not there was a conflict.
Well, we actually, through, using a database, provide the report, ourselves, put it together and analyze it.
But it's important to have that search.
Absolutely.
Not to skip that step for saving a few $100s. It's just not worth it.
Not worth it.
Yeah.
Agreed.
Common mistake number 4, assuming that because you are not aware of another company using your brand name, the coast is clear to obtain a trademark registration with the USPTO. And I think it goes in the same theme that we're talking.
Exactly. You can't just rely on what you know about the marketplace because there can be lots of surprises out there if you do that.
Oh, we talked about this just now. Common mistake number 5, attempting to perform a comprehensive trademark search without an attorney.
Yes, that is a big mistake. Usually when people say that they've done a search, they haven't done it extensively, number one, and they're not interpreting the results correctly.
Common mistake number 6, not knowing what intellectual property assets you have and therefore failing to take steps to protect those assets. Very important.
Yes, I often have conversations with people where they call my office and they say, "Oh, this brand protection thing, trademark. I haven't done it, but my friends are telling me that I should do it." And at that point, many companies engage me to help them. Like I sit down and I do a deep dive with their business. Like, what are they doing? What goods and services are they selling? What words and logos and slogans are they using? And we then can identify what needs to be protected.
Give me an example of IP assets that a company would have.
Well, you've got trademarks, copyrights, trade secrets, and patents. Those are the 4 areas of intellectual property where IP assets would fall under.
So a customer list, for example.
A customer list is a trade secret. I mean, you would not want your competitors to have your customer lists and all those details because you have a competitive advantage for having that. Now, that would be protected under trade secret law. However, in order to protect that, you have to make sure that you're not allowing that information to be accessible to everyone. You have to keep it in such a manner that you're protecting it.
What about email list? You have a customer email list that you send constant contact or any type of email blast. That's also your trade secret as well.
100%. And it's good to have your employees or contractors that work with you sign documents relating to confidentiality and non-disclosure.
Yep. And I also tell my business owners, you have to limit access. You got to give access to your employees to what they need to know. And some of the mistakes that I've seen some of my clients do is that they give this employee access to their email list, access to their customer list, everything. And then the employee leaves and some of that information is taken away. And this just becomes devastating.
Absolutely. I mean, I've definitely received those calls where a business owner is just totally distraught because somebody has taken the information. So the way to protect that, as you said, is on a need-to-know basis.
So you still got to have some, you can have the contracts, and NDAs, confidentiality agreements, but you also got to take some protective measures yourself that are common sense.
100%.
You know, if somebody's going to do a marketing campaign for you, don't give them access to the entire list. Perhaps give them access to the account on a limited basis, so that they cannot do anything with that email list that you have. They cannot download it, they cannot copy it, but they can do the campaign, or you have a compartmentalized process that, okay, you develop the campaign, then we send it up to another service that can do it. So you got to have common sense approaches how to protect that intellectual property.
Smart business practices, absolutely.
Yeah, that's very important. Mistake number 7, filing a trademark application with incorrect dates of first use, or not keeping evidence of the dates of first use.
Very important because it's use that establishes trademark rights. And so if you do not give the appropriate dates and that's challenged, you could lose trademark rights. For example, let's say you said you're starting to use the mark on January 1st of this year, but that wasn't true. You did not use it as a trademark on January 1st. And there's somebody else that wants the rights to the trademark, and they're then going to, and they started using it, let's say, on January 1st. They will then, if they can determine, stop you. They will have seniority and priority over that, and can move to cancel the trademark application or registration.
Well, one of the things we didn't talk about is the reality of trademark challenges in reference to the cost of litigation. And I try to keep people away from litigation as much as I can, simply because you can have a great case, but litigation is a battle of resources. It's not a battle who's right or wrong. You can have the best case possible, you can have everything in place, and you still will lose because you will run out of money.
100%. I really do my best to keep people out of litigation because most people can't afford it. Yeah. I mean, it's just, and this type of litigation, IP litigation, is very expensive litigation. I mean, we're talking about, if we're going the full distance, it's hundreds of thousands of dollars with expert witnesses, and the stress that puts on a business is just tremendous.
Yeah, financial stress, but also psychological stress.
100%.
And so, I try to keep them away from that. If you receive any type, sometimes people have to settle simply because if you lose that lawsuit, you will end up paying your attorney's fees, but also the other side's attorney's fees.
Exactly. And that can happen. And particularly if you've got a big corporate party with deep pockets that can afford the litigation and outpace someone that's a smaller business, then you're right, Rich. You need to consider, even if you're right, or the resolving it. How do we resolve this so it doesn't cause destruction to the company?
Yes. So, an ounce in prevention here is better than a pound of cure. And what you have here is, if you protect your brand, talk to a brand IP attorney like LA right from the very beginning, you'll have a plan on how to protect your brand all the way through your business journey.
Absolutely. I mean, peace of mind so you can build your business on a solid foundation is so important.
Common mistake number 8, thinking brand protection is not a priority and not budgeting for it.
Well, you kind of touched on that already, but very important for business owners to it's an investment. Just like they would get insurance, for example, general liability insurance. It's important. It's a form of insurance for your business.
Yes. So it is good to budget for it, and I think the initial cost, compared to, the initial investment you're making in a trademark registration, as you compare it to the potential returns you will have at the end, is worth it.
Absolutely.
It's by making that initial investment. So it's worth doing it. Common mistake number 9, thinking a United States trademark registration provides protection outside the United States.
That's right. It's basically, trademark protection is country specific. So if a business is doing business outside of the United States South America, for example, it's very important to get registrations in the specific jurisdictions in which you're selling your goods and services. And what can happen is you can get registration in one jurisdiction and not in another if you wait too long.
So if a business owner has a registration in the United States and they want to expand to Europe, what can they do?
Well, definitely speak with a lawyer who can connect them with lawyers in the jurisdictions. There's different strategies and different approaches for that, but it's definitely doable in terms of protecting in the other jurisdictions.
Common mistake number 10, thinking it is not necessary to use a brand protection attorney.
Well, we've touched on that several times in different ways. Just the importance of using legal counsel that can keep you and create a buffer so you don't end up saying things or doing things that are detrimental to your case.
I think it is very important as well to use an IP attorney because the brand is your business. And I do a lot of buy-sell transactions, and I will tell you that if you're selling your business and you have raised your trademark, will have a greater value. You will get more money for your business than if you do not have it.
100%. I've seen that happen over and over.
Because we do have one of the forms that we use is basically assignment of trademarks. We assign the trademark, and sometimes we go to the SPTO assignment. But when you assign that, you assign as part of your goodwill, and you're building that brand. And that brand recognition is what you're selling.
100%.
So, it's a great investment. Don't look at it as a cost, but it's an investment, especially at the beginning stages of your business.
It's absolutely an investment.
So tell me more. We have a few more minutes before we finish the segment. How can people find you?
Well, my office is located in Boca Raton, Florida, but I want to make the point that I do represent clients nationwide because it's federal law. So with the USPTO, people can find me by calling my office at 561-467-4001. My domain name is www.brandprotection.law. Email contact@brandprotection.law. And you can also be found on social media, LinkedIn, L.A. Perkins, Brand Protection Attorney will find me individually, and LinkedIn, Facebook, and YouTube is Brand Protection Law, Instagram, brandprotection.law.
That's very exciting. And this video also is going to be shared with Elaine. She'll be able to post it in her social media as well. It's important. Yeah, I'm glad you mentioned that point, Elaine, that if you're listening to this podcast and you're not in Florida, you still can work with Elaine. You still can give her a call. If you have a question about trademarks, she can service clients nationwide because federal registration is federal law, so it's nationwide. You're not limited only to clients from Florida.
That's correct.
Right. So I'm glad you made that point. The name of the book is Why Brand Protection Matters, How to Avoid Costly Mistakes and Increase the Value of Business is by L.A. Perkins. We're going to show the book again, and actually when you put the camera to you see the book. It is available on Amazon, Barnes & Noble. You can ask for your local bookstore, so I highly recommend you buy this book. So I close the show. If you have a legal question that you'd like to ask me, send me an email to rich@richsierra.com. If I select your question, I'll talk about your legal issue. I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is also available on Amazon, Barnes & Noble. You can ask for your local bookstore. We're excited that Brad Alea, a fellow attorney and also an author. So I'm very excited that you're joining us today. Come back again.
Thank you for having me. I'd love to.
All right. So this is the end of episode 62 of Business SOS. Again, this is Rich Sierra, and my goal is to help you succeed.